All right, is the appellant ready to proceed? Appellee ready to proceed? All right, you may proceed.
May it please the court. It is undisputed that Anisha Ituah is a mentally disabled woman and a qualified individual within the meaning of the Rehabilitation Act and the ADA. If her testimony that she was raped and immediately reported that rape is credited, as it must be at the summary judgment phase, then the deliberate actions of Austin State Hospital staff in actively destroying the evidence denied her access to ASH's service or program of investigating sexual assault.
What evidence is there that the hospital destroyed evidence?
The hospital instructed Ms. Ituah to take a shower immediately after the reported incident. The hospital washed the bedclothes and sheets, which may have contained the physical evidence, if Ms. Ituah's testimony is believed, likely would have. And there was a videotape of the corridor that would have had crucial evidence about how long the assailant had access to the room and how he gained access to the room.
Weren't there other entities that were investigating this, not ASH, but other entities?
There is a memorandum of understanding that divides the responsibilities for investigation. Under that memorandum of understanding, ASH is responsible for the initial interview and for the evidence preservation steps. ASH is the entity that's ultimately responsible for that preservation. Under that memorandum of understanding and under ASH's policies, DFPS is supposed to be called within 1 hour of a report of a sexual assault. In this case, DFPS was not called until the next morning, by which time Ms. Ituah had been instructed to shower rather than a sexual assault examination occurred. The bed sheets and clothing had been washed. Video non-preservation, we believe, was a matter of a regular 30-day destruction cycle. But again, I would argue that those are intentional acts and not mere negligence. They are also in violation of the written evidence preservation policies in ASH's. And we believe that those were taken by reason of Ms. Ituah's disability. And the evidence for that is that when Ms. Ituah told the first responding ASH staff in her testimony that she had been brutally raped by this man, ASH staff laughed at her. Now that laughter is a hallmark of the sort of condescension, discrediting, and mockery that is a hallmark of discrimination against the mentally disabled.
Okay. Now, look, under our precedent, Lance, there are 5 steps that one would have to show. You show ADA or RA claim based on sort of peer sexual harassment. Lance, right? That's the one that extends Davis out of the Title IX context into the ADA. So, I'm sorry, do you disagree with that? I mean, isn't that our precedent?
I agree that Davis is one path by which, and Lance, as it's applied, is one path by which a plaintiff can show discrimination or denial of benefits under the ADA, ultimately. Davis is not the exclusive remedy. There can also be claims for direct discrimination and claims for failure to accommodate that don't invoke Lance or Davis.
Lance, you're saying Lance doesn't factor into your claim at all?
Lance does factor into our claim.
So since it does, the second prong is that the plaintiff was harassed based on her disability. How is the harassment here, I assume you would say, is the alleged rape. How is that based on her disability?
I think that we are forthrightly asking for an extension or at least a modification of Lance as to that second element. The purpose of Davis...
So you're saying it wasn't?
I'm saying that the motivation of the hospital and its denial of benefits or services to the victim, to the qualified individual, is the relevant inquiry. That Davis says that one way you can prove that is... So the paradigmatic Davis case is where you have a coeducational environment and, women are being discriminated against, or disabled people in a mixed environment are being discriminated against. I would argue that in this narrow case where all of the recipients of Austin State Hospital's benefits and programs and services are disabled individuals, if there is a pattern of known assaults on those individuals that Austin State Hospital is aware of by individuals in their control, and they deliberately disregard that pattern, that the fact that we don't know the assailant's motivation, the question is whether or not ASH is denying those benefits and services
Well, I
based
mean,
on
you're being
disability.
candid, and I appreciate that it's an extension of Lance, but, I mean, you're reading out that would read the second prong out of our law.
I think the second prong would most often be necessary in the paradigmatic case, but I think that the important point is that Davis contradicts the district court's claim that there is a categorical ban just because it is sexual assault involved by one patient against another against finding liability. Davis is an example of a case where you can, but also it's very clear, and to be clear, I think we argue both discrimination and failure to accommodate. In both, the failure to provide a safe environment and the failure to investigate. I think that the clearest and most compelling evidence has to do with the discrimination and the failure to investigate.
I want to get back to Davis because I want to make sure I'm understanding what's happening. Prong 2 of the Davis test is that the harassment or the assault has to be based on her disability. Am I right? And I may be wrong about that.
You are right,
That's prong 2.
as stated in Lance.
All right, but didn't you say in your brief that you're not claiming that she was assaulted because of her disability?
I agree. The Supreme Court's language in Davis,
So you're saying despite the fact that you disavowed that has anything to do with the assault, your claim should still be allowed to go forward?
I'm saying first that Davis is not the only path to prove a case of prima facie discrimination under the ADA. I'm saying second that to the extent that the claim is for the sexual assault in the Davis sense, that in this environment, the purpose of Davis originally was it's by analogy to the hostile workplace environment. And the purpose of Davis...
I don't mean to cut you off.
No, go ahead.
If I understand you correctly, is you don't feel constrained by Lance Davis, any particular doctrine, because what you're saying is, as an original matter, there should be an additional cause of action that we should recognize for the first time. You're allowed to argue this, that would exist under ADA but has not heretofore been recognized. Is that sort of your... I think that's what you're saying.
I think that's a fair...
What does that cause of action look like? Talk to us about...
It looks like the text of the ADA, in which there's a qualified individual who's being denied the benefits, services, or programs because of their disability. And the way that it would be proved in this case is that, in the words of the Davis Supreme Court...
Here's the issue. If you don't mind, let me ask a threshold question. When you opposed summary judgment, right?
Yes.
I take it you argued ADA, Rehab Act. Any other cause of action we need to be aware of? Or
No.
That's the landscape for this appeal, right? Look, these are horrifying facts. If there is not law today, I would hope that legislatures would look at obligations that hospitals need to take to combat sexual assault or to at least have them properly investigated. But we're here on a disability case. Don't you have to prove the disability discrimination part of it, separate apart from the horrifying sexual assault?
Absolutely, Your Honor. And I think that that is most clearly demonstrated in the discriminatory and intentional decision not to follow ASH's written policies of evidence preservation, but instead to laugh at the complainant and the outcry witness, to laugh in her face and instruct her to shower, and not to call DFPS until the next morning, by which time crucial evidence...
Just saying that discrimination wasn't based on disability, and it doesn't have to be in order for your claim to be successful.
No, Your Honor. To clarify, Ash's discrimination was based, the staff's discrimination was based on Ms. Ituah's disability. They mocked her and did not believe her as a disabled woman and did not take these claims seriously to such an extent that they failed to follow their policies. Ash points to their policies which were not followed in this case and amount to a list of the services or programs that were denied to her.
If she had not been disabled, they would have behaved differently.
I believe so. I believe
They would have investigated, they would have not laughed at her, they would have...
I believe a reasonable jury could reach
What
that
is your
conclusion.
evidence, since this is summary judgment, what is your evidence that had Ms. Ituah not been disabled, she would have gotten full protection from the hospital?
I think that the most powerful evidence is in Ms. Ituah's own deposition testimony, her account of how she described the assault, her account of how she described the assault in
That's a
police
description
video.
of her, I'm sorry to cut you off, but that's a description of her own treatment, which I understand she believes was terrible. But is there any evidence that in a different case, not her, but somebody who is not disabled, suffers through a very similar circumstance, the treatment would have been different? What's the evidence of that, the comparator evidence, if you will?
Well, comparator evidence is uniquely difficult in a situation in which all of the patients at Austin State Hospital, almost by definition, are qualified individuals. But it is difficult to imagine an outcry witness. Let's say it is a 12-year-old girl with the equivalent mental capacity as Ms. Ituah. You know, I think it is difficult to imagine a first responder of any kind reacting with laughter and saying, "Go take a shower." And that, you know, I think that if this were a staff member, it is difficult to imagine. There may not be direct comparator evidence. I don't have a case of a specific staff member at ASH who was victimized by a patient and was then taken seriously and had these policies carried out for them. But to me, it really comes back to the laughter as evidence that what was at play here was a disregard and a failure to take her seriously, and that's the only available explanation for the failure to follow ASH's own policies.
So is the idea then, the narrative I'm hearing you is the assailant, you're conceding the assailant was not motivated by disability.
We have no evidence of the assailant's motive.
Right. But at the hospital level, you believe it's sort of res ipsa loquitur that had this been a non-disabled person, of course you would have taken this seriously. And it's only because she was disabled that you behaved this way.
It only because of would be the standard under the Rehabilitation Act, but under the ADA, it is by reason of disability. We do not have to prove that it is only the cause.
Fair enough. I was trying to. The point is, in your view, it's enough that at the hospital level, disability made the difference by reason of, even if we agree that the assailant was motivated by something else.
I think that the testimony about the laughter, the testimony about specific requests for a bag to put her clothes in that were denied, the testimony from her mother that she called and asked for a sexual assault examination and that did not occur, if this was ignored, if this evidence is credited, then it is mind-bogglingly appalling. And if there's any, if frankly any, hole in the evidence here, it is the state's doing by denying her the basic service of preserving the evidence, which is ASH's responsibility under the Memorandum of Understanding. And to be clear, I think we talked about Davis.
Investigated by anyone other than ASH?
Yes. The Department of Family Protective Services conducted an interview of both witnesses the next day. We believe that investigation was inadequate, but...
Did you sue them too?
We did not. We did not.
Did you sue the assailant?
The assailant? No, sir. Our understanding is that the assailant is deceased.
Who else besides the Department of, did you say Public Safety?
The Department of Public Safety, Ms. Ituah went to the Austin Police Department some months later and conducted an interview. The Travis County District Attorney opted not to bring charges.
Did they investigate? I mean, someone comes to them and says, I was brutally raped. Did they investigate?
There was an investigation. There were some phone calls made. There was ultimately a non-prosecution decision made. There was a civil suit involving that non-prosecution that I believe settled out of court, but that was not, Ms. Ituah was a member of a victims class in that suit against the Travis County District Attorney and the City of Austin, I believe. If there are no questions at this time, I would ask to reserve my time for...
Thank you, counsel. Mr. Watson, all right, you may proceed.
Thank you, Your Honor. May it please the court, my name is Ben Walton, and I represent the Austin State Hospital. Your Honors, the ADA...
Is it Watson or Walton?
It is Walton, but I very often answer to Watson, Your Honor.
Our sheet says Watson.
Our sheet says Watson.
It is W-A-L-T-O-N.
Ah, okay, all right.
Should we let him on?
Huh?
Strike it.
So that the record clearly
That's a
reflects.
typo. Your brief says Walton.
All right,
You're good.
go ahead.
Thank you, Your Honors. The ADA and the Rehab Act do not apply to Ms. Ituah's claims arising out of an alleged criminal assault by a third party.
I read that in your brief, but then, I mean, doesn't that run up against our courts extending Davis to the ADA context? In other words, can we, isn't it difficult for us to accept that kind of large claim that you're making, that's kind of blanket legal claim that you're making because of Lance?
To clarify, Your Honor, the claim that Ash is making is that where there is no evidence connecting an alleged sexual assault to a disability, there's no causal link. Therefore, it fails to meet the requirements of Davis as expressed through a state of Lance, and the ADA is not the proper vehicle for a recovery in that case.
Now I understand what you're saying. Okay.
Sexual assault per se, considered by itself, is not actionable
Without any
under the
causal
ADA.
connection to disability. You're saying the
Precisely.
Lance test, which is those 5 factors, you got to meet number 2.
Precisely, Your Honor. And plaintiff primarily below was focused on the Davis theory. That was primarily her theory that was litigated throughout discovery and the summary judgment portion of the ADA and Rehab Act claim. But I did also want to bring to the court's attention, I believe Judge Ho asked, were there other claims that were also the subject of summary judgment? To be clear, Ms. Ituah also pleaded and went through full discovery and summary judgment on her 1983 claim. That claim is where, under DeShaney from the Supreme Court and its progeny, the Supreme Court has said this is the federal cause of action where we analyze whether state entities provide a reasonably safe environment for those committed to the care of the state. That claim is not before this court. Ms. Ituah also had that claim dismissed on summary judgment on the merits and chose not to appeal.
That would be a special relationship type fact pattern that wouldn't require discrimination at all.
Not on the basis of a disability.
Right.
That's Your Honor.
That's just the 1983 DeShaney special relationship idea. I get that that's not before us. I get why you're saying that. But there is a disability discrimination claim here. And so what I'm continuing to struggle with is the following narrative that the other side's putting forward. Stipulate that the assault had nothing to do with disability, okay? But stipulate the following fact pattern. This hospital, again, I'm not saying it's in the record here, it may or may not be, but the idea would be a hospital will routinely, aggressively investigate and deal with sexual assault if it's not disabled, if the victim's not disabled. But if the victim is disabled, they laugh at it, they cover it up. Is that actionable? I'm not saying that's this case, but is that actionable, notwithstanding Lance, as an original matter under ADA and Rehab?
It could potentially be actionable, but thankfully that is not this case.
Okay, so you're not disputing the cause of action theory that's being put forth. You're saying there's just utterly no summary judgment evidence of that level of discrimination at the hospital level.
Well, Your Honor, it is our understanding there are multiple theories being put forth. So the Davis-Lance theory of you're responsible when peers harass other peers.
I think they've stipulated they don't have that pure Lance theory because the assailant just wasn't motivated by disability. What they're saying, I think, my word's not theirs, as an original matter, look at the ADA, my goodness, it obviously prohibits disability discrimination. Why should it matter that the assailant's motivated or not? All that matters is that the defendant is motivated or not.
Yes, Your Honor. With regard to that particular theory, that theory would trigger an investigation of the evidence. The record here is devoid of any evidence showing that ASH has failed to follow its policies to properly respond and protect its patients in any other instance, whether the alleged plaintiff victim was disabled or not. And to step back even further, even though ASH didn't have the burden of proof here, through discovery, it produced tens, if not hundreds of thousands of pages of documents relating to all of the assault allegations and ensuing investigations performed by the outside investigators for a period, I believe it was multiple years through discovery.
Of other sexual assault
Of other alleged.
allegations at this hospital. Okay.
That's right, Your Honor. And so that was all turned over to Ituah's counsel during discovery. Up through discovery and even at the summary judgment time, there has been no identification of any other instance, any other example where ASH staff failed to follow these policies, where ASH staff discriminated against, failed to provide services to any other patient at ASH. And
The idea is there were other allegations by disabled individuals. Those were fully investigated. For whatever reason, this one may not have been, but that doesn't tell you it's sort of disability discrimination. That's what you're saying.
Yes, Your Honor, with the exception that, of course, ASH does not concede that this was not properly
No,
investigated.
I understand. But
of course,
your point is, there are plenty of examples where the person was disabled and ASH was very aggressive.
Absolutely, Your Honor. And in our brief at footnote 11, we cited pages 805 and 806 of the record where we provided affirmative evidence to the district court, because the district court was curious about this as well. Cited where ASH did merely a sampling review of those several hundred thousand of pages of documents and was able to provide affirmative instances where ASH staff had specifically followed these exact same policies for other patients with acute psychiatric disabilities, and Ms. Ituah has failed to provide one other example where they didn't. Every patient that comes to ASH suffers from an acute psychiatric illness. That's why ASH exists, and that's why patients get sent there. So I would stop short of saying that every patient who walks through ASH's doors is a qualified individual with a disability under the ADA, but there's a huge overlap there. These are the people that ASH treats every day. These are the people that ASH staff consistently protect and follow policies, and the evidence here, when viewed in the light most favorable to Ms. Ituah, shows that, as alleged, a jury might conclude that on one night, some of the employees followed some of the policies, but not others, and that something bad happened that night. Those facts, if true, are horrific, but they do not rise to the level of a pattern of discrimination that would give inference to a motive of discrimination based on arising out of a disability. That is why this case, if anything, should be analyzed within the rubric of 1983 and DeShaney for the simple failure of a state facility to keep its patients safe, and it was by the district court, that's not before this court. This does not all get shoehorned into the ADA and the Rehab Act where there's no connection to a disability.
Right, you all don't deny that this would satisfy the special relationship, whatever the DeShaney test is, as I recall. You have custody of this person.
Yes, Your Honor. There were various arguments made on plaintiff's 1983 claim below. Specifically, she had tried to plead it as an equal protection claim, not a due process claim. DeShaney applies to due process, but not to equal protection. But in the end, the parties fully briefed it as if DeShaney applied, and what does the evidence show? That's what the magistrate judge in the report and recommendation analyzed. That's what the district court looked at. That's what the ruling was. On the merits of a full-on DeShaney analysis, the court dismissed that claim for insufficient evidence. That is not the analysis that Ms. Ituah now gets to transfer out of a 1983 case, put into an ADA case, and simply say that, well, even though there's no connection to disability, same analysis should get me recovery under the ADA as well. If there is any responsibility for peer-on-peer harassment under the ADA and Rehab Act, it must flow through the line of Davis and Estate of Lance in order to state a claim for disability discrimination. If there is a claim for direct disability discrimination, then there must be evidence of, as plaintiff concedes, a pattern. Admits there must be a pattern. Here, there's one instance. Again, that instance is hotly contested as to what happened that night, but viewed in the evidence most favorable, there is one instance. That is not a pattern that permits an inference of deliberate indifference, which is a high bar.
You may have been talking about this in some related way, so forgive me if I missed it, but is there a distinct claim for failure to accommodate here? And if, whether there is or not, could you respond to the allegations made in the briefs about a failure to accommodate, say by failing to put locks on doors, that sort of thing?
Certainly, Your Honor. And to clarify, there are two distinct theories of recovery, both of which were argued below under the ADA and Rehab Act, the direct discrimination and the failure to accommodate. The direct discrimination really arises not in a failure to prevent sexual assault, but providing adequate criminal response services at an institution. The failure to accommodate claim comes in on the front side of that, failure to have accommodations that Ituah argues would have prevented this from happening in the first place. There were several accommodations that were litigated through discovery, I believe a total of 5. When it came right down to the expert report, the expert opined on, well, purported to opine on 2 of them. One was an inadequate sight line from a nurse's station down a hallway that she alleges could have prevented this assault from happening. The second accommodation was the failure to have internal door locks on patient bedrooms at a psychiatric facility. There were other proposed accommodations such as tracking devices and call buttons and video monitors and so forth. The expert in her report offered no opinion on those matters. Right? So the sight line, the expert said, could have been a problem, and this is Ituah's expert, not the rebuttal experts from ASH. The sight line could have been a problem, but she never inspected it and never updated her report to say that, in my opinion, this sight line is deficient. So without any of that evidence, the sight line issue is an irrelevant accommodation to consider further. If that were relevant, of course, ASH's expert provided testimony that the sight line was sufficient, and there's factual testimony that shows the staff doesn't even rely on a sight line. They're out there beyond the glass, mixing and mingling in the patient areas to monitor that. The second accommodation, the door lock issues, as the magistrate judge analyzed in the R&R, there is no demonstrated expertise of plaintiff's expert on door locks, what's on the market, what's feasible, what's not. She simply says it might have made sense for you to let patients lock their doors. Maybe that would keep them safe. ASH then provided affirmative evidence specifically to say, no, door locks on patient doors at a psychiatric healthcare facility are affirmatively dangerous. That's why psychiatric facilities in the country don't do that. Because even if there's a staff override capability, it still takes several seconds to perform that override, which could result in more harm and more serious injury happening in those intervening seconds at a facility that houses acute psychiatric patients. So for that reason, the magistrate said the unrebutted testimony showed that none of these proposed accommodations, while theoretically possible, were actually, there was no evidence showing that they were feasible to accommodate at this particular facility. No sufficient evidence from an expert that could even support a jury finding on that one way or the other.
Thank you.
Your Honors, because the ADA and the Rehab Act are limited to discrimination that arises out of a pattern of disability-based differential treatment in the benefits and services provided, because that is absent here, the ADA and the Rehab Act are simply not the vehicle through which Ms. Ituah must bring a claim for recovery. If anything, I suppose a state law cause of action would be a separate issue that she chose not to bring and that we haven't analyzed, but if any federal cause of action...
Is there a state cause of action you're thinking of?
Not that I'm aware of, Your Honor. I know that between the different laws of different states, they have different abilities to sue for negligence, medical malpractice, et cetera. But those were not pleaded, those were not at issue here. But in federal court, Ms. Ituah has had her full chance to litigate the DeShaney theory of 1983 and has chosen not to appeal that. This court should not expand the scope of the ADA and the Rehab Act to cover what conceptually is already provided for by the Supreme Court in DeShaney. Thank you, Your Honors.
Thank you, Counsel. Rebuttal.
Your Honors, may it please the Court. There are two bad acts that make up the basis for Ms. Ituah's claims. One is the failure to prevent a sexual assault. That theory requires Davis or some extension of Davis and Lance. The other is the straightforward denial of the services and programs that ASH, by its own policies, is supposed to provide to complaining witnesses who say in the terms of Ms. Ituah's testimony and were brutally raped and who specifically requested bags to save their evidence, etc. That theory is analogous to Delano, Pyle, or Perez, or even Cadena. It's a straightforward ADA claim in which a accommodation or a interview that takes her seriously is required, and she is denied the access to ASH's services and programs, specifically its obligations under the Memorandum of
So
Understanding.
opposing counsel, I think, says you have no evidence of other disabled patients who were similarly denied, let alone non-disabled who were granted.
I think my response would be that in Delano Pyle, it wasn't asked whether that police officer adequately interviewed non-disabled drivers. You didn't need a comparator to know that you need a American Sign Language translator for a hearing impaired person. You don't need, in Cadena, the provision of crutches. There is a service that is, these are accommodation cases, but this, to me, it's as, it seems that it's not reasonably disputable. It's undisputed that Ms. Ituah is a qualified individual. It's not reasonably disputable that she did not receive the services and programs that are set forth in ASH's policy manuals, if her testimony is credited. So the question then becomes whether that denial of those services were on the basis of her disability. And our best evidence of that is that they laughed in her face. Our expert witness, Eva Kutas, opined that ASH's interview process imposed a de facto screen that refused to take complaints from mentally disabled complaining witnesses seriously. And the pattern shown in the statistics, that there is an outcry at Austin State Hospital on average more than once a week. At most, according to defendants' records, and we don't dispute this, but at most on 5 occasions over the past 10 years, I believe. I'm not positive of the amount of years. I can confirm that to the court in a
What's the
letter.
body in Texas that oversees, the regulatory body that oversees hospitals like ASH?
I'm sorry, I don't know that now.
I would think that, given what you're saying, did you say once a week?
Yes.
That this place would have been shut down long ago, and there would be evidence of investigations into a place where there's once a week sexual assaults happening.
There's an outcry of sexual assault once a week. And fewer, in the 3 years preceding Ms. Ituah's outcry, none had been confirmed. We think that a reasonable jury, given the flagrant denial to provide Ms. Ituah with the very basics of preserving her evidence so that the facts could come out accurately, in the face of a really upsetting account of having been raped. And the ASH policy handbook says even in cases of attempted rape, even when a crime may have occurred, Austin police are supposed to be called. Here, if Ms. Ituah's testimony and Ms. McKay's testimony about their outcry is credited, as it must be, then this was written in fire for the investigators. And that is a unavoidable fact question. I think that if
I'd like to clarify, the other side said they gave you, I think, tens of thousands of pages documenting other outcries that were fully investigated, and therefore, I think that's what I heard, And therefore, to the extent that that wasn't done here, they denied that it wasn't done here, but to the extent that it wasn't, the distinguishing factor was not disability, since others were. Are you telling me that is a false description of the record, and in fact, it's the opposite, that there were a lot of other incidents of disabled outcries, and they were also not pursued, and that's why you're here?
They were also, for the overwhelming majority of those outcries, no evidence was preserved. Ash's corporate representative was unable to recall a single instance of the video having been preserved, or of a rape kit having been performed, or of clothing and bed sheets having been performed. After the hearing on the motion for class action certification, at which I argued that corporate representative's lack of knowledge of any, who was noticed to testify about all of these investigations, when I argued her lack of knowledge after that hearing, the defendant wrote a letter to the court and clarified 5 instances where one of the policies, maybe in some instances multiple. I think that I could probably craft an agreed letter with the other side, but we're talking about a matter of fewer than 1% of the outcries result in any of these evidence preservation policies being carried out.
Thank you, counsel. Court will take this matter under advisement. We are in recess until tomorrow afternoon.